Hey everyone, welcome to this explainer. If you're a student of public administration or honestly just someone fascinated by how government actually functions behind the scenes, you are absolutely in the right place. Today we're breaking down a foundational power play from 1803. It's a case that literally set the rules of the game and still governs exactly how much power our public officials really wield today. But before we dive into the nuts and bolts of the government machinery, I want you to ask yourself a really fundamental question. Think about this. When administrative or legislative powers overreach, who ultimately holds the authority to stop them? Like, who actually keeps the bureaucracy in check? Here's our roadmap for today. We're going to hit the bitter political rivalry, the undelivered commissions, John Marshall's legal trap, the genius ruling itself, the origins of judicial review, and finally, its global constitutional legacy. Okay, Section 1, a bitter political rivalry. Because to understand the law, you really have to understand the messy politics behind it.
The transition of power back in the early days of the United States was, well, it was total chaos. In the election of 1800, Thomas Jefferson and his Democratic Republicans defeated the incumbent Federalist President John Adams. But before Jefferson could actually take office, Adams and his lame duck Federalist Congress passed the Judiciary Act of 1801. This essentially allowed Adams to rapidly appoint dozens of Federalist judges right before his term ended. We're talking appointments being made literally up until the stroke of midnight.
Basically, the outgoing Federalists utilized that Judiciary Act to deliberately jam up the incoming administration's policy agenda. By packing the federal courts with loyalists, they were trying to keep a tight grip on power even after losing the election. It was a purely partisan maneuver, completely designed to keep the new executive branch tied up in legal knots. Section 2, the undelivered commissions. And if you're studying public administration, pay close attention here, because this is a masterclass in why your paperwork actually matters. So here's how a simple administrative bottleneck sparked an absolute firestorm. Step 1, President Adams signs the judicial commissions. Step 2, his Secretary of State, John Marshall, stamps them with the official seal. Step 3, Marshall, caught up in the crazy rush of the transition, accidentally fails to deliver a handful of them before Adams's term expires at midnight. And then Step 4, Thomas Jefferson takes office, finds these undelivered commissions just sitting there, and orders his new Secretary of State, James Madison, to withhold them. Just like that, a simple failure of the outgoing administration to deliver paperwork on time created a high-stakes constitutional standoff. Now, one of the guys left empty-handed was William Marbury. To bypass this bottleneck, Marbury sought what's known as a writ of mandamus. Think of it as a court order compelling a government official to just properly fulfill their official duties, basically saying, do your job. Marbury went directly to the Supreme Court, asking them to issue this writ to force James Madison to hand over the commission. Section 3, John Marshall's legal trap. Suddenly, the very survival and legitimacy of the entire judicial branch was on the line. Chief Justice Marshall found himself caught in the ultimate lose-lose trap. Think about it. If the court issues the writ, Secretary of State Madison, acting on Jefferson's orders, is probably just going to ignore it. The court didn't have an army to enforce its rulings, right? So that would expose them as completely powerless. But on the flip side, if they don't issue the writ, the court looks like a weak political puppet just backing down to the new president. Either choice seemingly destroys the authority of the Supreme Court. And to make matters even wilder, Chief Justice Marshall had a massive conflict of interest here. I mean, he was the former Secretary of State who literally forgot to deliver Marbury's paperwork in the first place. Plus, Marbury sued under Section 13 of the Judiciary Act of 1789, which allowed him to skip the lower courts entirely and go straight to the Supreme Court. That's a little thing called original jurisdiction. Naturally, whatever Marshall decided was going to be heavily scrutinized by his political rivals in the Jefferson administration. Section 4, the genius ruling. So how on earth did the court escape this impossible trap? Marshall was brilliant. He broke the case down methodically into 3 questions. 1, does Marbury have a right to the commission? Marshall says yes, absolutely, it was signed and sealed. 2, is a writ of mandamus the proper legal remedy? Again, yes, the law provides for it. But question 3, does the Supreme Court actually have the constitutional authority to grant it? Marshall answered no. He determined that while Jefferson's administration's totally in the wrong, the court simply lacked the power to fix it. But why did he say no? Well, let's compare the text. Section 13 of the Judiciary Act, passed by Congress, granted the Supreme Court the power to issue these writs in original jurisdiction. However, Article 3 of the U.S. Constitution limits the Supreme Court's original jurisdiction strictly to cases involving states or foreign ambassadors. And Marbury? He was neither. So the crucial takeaway here is that Congress's law unconstitutionally expanded the court's jurisdiction, and because the Constitution is supreme, Marshall declared that the conflicting law was simply null and void. Guys, this was an absolute masterstroke. By voluntarily denying itself a small, relatively minor administrative power to issue this one writ, the court brilliantly established the massive concept of judicial review. That's the power to review and overturn legislative or executive actions that conflict with the Constitution. Marshall essentially looked at Jefferson and said, hey, you win this small battle, but we win the ultimate war of who interprets the law. The court cemented itself right then and there as the ultimate check on legislative and executive power. And then Marshall drops this absolute mic drop quote. It is emphatically the province and duty of the judicial department to say what the law is. That single sentence permanently defined the separation of powers for us. It meant that a law passed by the legislature or an action taken by an executive administrator cannot violate the Constitution, and it's the courts who get to make that final call. Section 5, Origins of Judicial Review. Now let's take a step back for a second. Was this massive administrative concept really just invented out of thin air in 1803? Actually, no. The historical record shows us that judicial review wasn't entirely Marshall's invention. Precedents already existed in state courts, and you can even trace it back to English common law well before Marbury. Early courts were actively using this power to police the boundaries between different governmental entities. And for those of you studying public administration, it's really vital to note that early judicial review wasn't primarily about protecting individual human rights. It was designed as a structural tool. It was there to maintain the separation of powers and prevent legislative or executive overreach. Section 6, A Global Constitutional Legacy. Finally, let's take a look at how these principles laid a global blueprint for public administration far beyond America's borders. You know, Marbury's logic has actually echoed all over the world. Take Israel's landmark 1995 Bank Hamizrahi case, for example. Just like the U.S. in 1803, Israel had no explicit constitutional text expressly granting the Supreme Court the power to strike down legislation. Yet Chief Justice Aharon Barak perfectly mirrored John Marshall's logic. He derived the power of judicial review from Israel's basic laws to establish the court as a vital check on legislative power. So all of this goes to show that Marbury isn't just some dusty piece of history trivia. The entire modern administrative state fundamentally relies on this delicate system of checks and balances. Whether you're in Washington, D.C. or Jerusalem, it serves as a living blueprint for democratic governance, ensuring that public administrators and elected officials are always accountable to a higher fundamental law. Which brings us to the end of our explainer. I want to leave you with a really provocative thought to ponder, especially for your own future in public administration. In an era where we see constantly expanding executive and bureaucratic power, is this unelected judicial check on power our greatest protection against tyranny? Or, as Thomas Jefferson deeply feared, is it a risk to democratic administration itself? Really think about it. Thanks so much for joining me, and keep questioning how our government works.